The CPI report, Child Protection in Iowa, is brought to you by Vocal Victims of Child Abuse Laws. You can watch our program on Sunday afternoon at 1 o'clock. Again, it's repeated on Wednesday evening at 9:30, all on Mediacom Cable Channel 15. You can email us at vocaliowa@mchsi.com. My phone number for parents to give us a call is 276-3956, or John's number is 282-2672. My name is Don Burgmaier, and with me at the controls is my co-host,
John Harvey, and welcome to the CPI report. Some people ask, how is it, or what is it that you're asking, or that you're actually doing? And I know for a number of months in a row we were stating what our real mission was. It's actually twofold. One is to influence public policy as it relates to child protection issues. And the second part of that mission is to assist people who are having difficulties with the Department of Human Services. And the question may rise, are you attorneys? And the answer is no. We attempt to assist people who have difficulties with the department. We can give you hints. We don't practice law, unauthorized practice of law, so we don't practice being attorneys. So if you want that kind of service, you'll have to find a licensed attorney, and good luck in finding one that will do the task for you. There are some roundabout. I think you can count them on your left hand throughout the state.
maybe your left fingernail.
That's right. There may be one or two that could be skilled in the areas that you're thinking about.
Oh, be sure that they'll tell you that we'll win the case in 3 months, too.
As soon as they get their upfront money, then they're good.
3 months comes and goes, and there goes your kids. And
Right.
I thought he said he was going to win in 3 months.
The problem is even wealthy people who can hire very skillful attorneys don't always win their case because of the structure and the way laws are put together. There are some difficulties that the state legislature is looking into. One of them is on the extremely high divorce rate. A number of years ago, they took no-fault divorce out. And what it did was it opened the storm gates and just flooded our state with all kinds of problems. There are all kinds of problems that arise from divorce, particularly when there's children involved. And one of the statutes, or one of the things that they're working on right now, is the House Study Bill 69, which has a lot of good things in it. But one of the things they're talking about is using such things as a guardian ad litem in divorce case. Well, a guardian ad litem should be used only where it is clear that there is a fundamental difference in the legal interests of the natural parents and the child. And it appears as though, as I read that, it looks as though they're trying to intermingle the concepts of law from the juvenile court and try to mix those in as a part of divorce code, which should never be. Divorce code should be more of a contractual type of arrangement. And unfortunately, with the divorce code as it is now, with no fault, it is more difficult to enforce that agreement, which was made voluntarily, was made as a lifetime agreement, and to keep that agreement together, it's more difficult, or it's easier for a newspaper boy to collect his, for delivering papers than it is to enforce the elements of a marriage, which I think is a pretty clear disaster case. Well, talking about divorce, this is the ex. And I guess I put her picture on the screen for a couple of reasons. Number one, she's coming up on a birthday. Probably shouldn't tell her age, but she was born 62 years ago. So, uh, and her real accomplishment, and the reason why Caldwell Banker has her pictured in Sunday's paper.
Who does?
Caldwell Banker has her picture. That's a real estate firm. Has her picture in the paper because she sold.
Stayed with her. She's got a lot of money.
$4.7 million worth of real estate, and looks like it's been a real task for her. It looks like she's been pulling out of her hair in accomplishing that task. But congratulations on both birthday and upon this honor shown to you by your company, Caldwell Banker.
No, you're not feeling nostalgic because of the Valentine's Day. Right?
No, never did too much with Valentine's Day.
Okay.
But she was in on this divorce thing and found out that that it pays. The one who petitions is the one who usually cleans up. I have a rather strange way of approaching that divorce thing. What I would say is that the one who petitions for divorce should be able to go to the court and, without any reasons or anything else, simply tell the judge that he or she wants to be divorced. By the way, most of these are filed by the women. 70 to 80% of them. In fact, all you have to do is look in the newspaper, and you can tell who it is that's doing the filing. And the judge would simply say, divorce granted. Now, I don't want to hear anything more from you because you got the one wish that this court can grant you. You wanted a divorce? Granted. Now I'm going to talk to the other party about everything else. And I think that would slow the divorce rate down to a screeching halt. There would have to be some code written to take care of the extraordinary cases where divorce was probably the right thing to do. But for 99.4% of the cases, I think that would be the right way to treat it. Petitioner gets the divorce. The respondent gets to talk to the judge about everything else, including real estate and children and everything else that falls into the jurisdiction of the court. And I think that would solve the problems in a hurry. Maybe that's a quick fix that is laughable, but maybe not as easy to come by. Well, today we're going to see a part of a videotape of the presentation of the evidence against John Harvey. And before we get to that, however, we're going to hear from Terrance. He has a number of court cases that he's looked at that are rather, some of them give you chuckles and some of them give you a little bit of pain. But most of you who have been through this, have been watching this program, know that I was arrested on March the 24th for interference with official acts. That's when I went into the courthouse, camera in hand, with the intention of videotaping on extended media coverage, which I had appropriate order. I had to go all the way through a trial, had to take it through appeal. 3 judges and 1 prosecutor, being members of the bar, all forgot that they are supposed to follow the law and the Iowa Rules of Criminal Procedure. Well, they didn't do what they were sworn to do. The problem was they didn't bother to make sure that the matter brought before them was an appropriate matter according to law. Law says that whenever a simple misdemeanor is brought, and this includes speeding tickets and everything else, it has to be on a sworn to affidavit. And my case was not sworn to, and I proved that in court. And no one wanted to listen, including Carol Agley, including Judge William Price.
Is this
And
Egley's name down here?
it's hard to tell whose name it is, but I'm told by the judge that the judge recognized it as being Carol Agley's name. There was one other name that was mentioned in here, but I don't see it in any documentation.
And up here, I can't pronounce that name.
And I can't pronounce that name either. So it's not a sworn to affidavit. And even after I'd gone through a jury trial and had taken it on appeal, and the appeal or the trial court was held by Judge Novak, and Novak, I don't think, ran the ship appropriately. Certainly, he refused to give any consideration whatsoever to my constitutional complaint that there was no sworn to affidavit bringing this to
Do you have a
the court.
copy of his ruling?
No, I don't have a copy of that.
I thought that would be interesting if
Do you have it in hand?
Had a copy of that.
No,
You-
I have a
asking
copy.
you.
Oh, I have a copy of not Novak's ruling. I have a copy of the ruling of Judge Robert Blink, who is
Okay.
the appeals court. Now, on this 4th day of February 2005, the state's motion to dismiss. By the way, the prosecution finally owned up to the fact that they weren't doing things right. But it was heard by the court. The matter was reported but not contested, and the state was represented by Assistant County Attorneys Justin Allen and Fred Gay. Defendant was pro se. Well, that's the only way I can afford it. This is an appeal of a simple misdemeanor conviction. Prior to trial, defendant moved to dismiss the prosecution based on a failure to comply with Iowa Rule of Criminal Procedure 2.54. You see, I know the rules. They don't.
What is a pro se person, John?
Pro se? You tell what your concept of pro se person is.
You file papers without an attorney helping you. You sign your own name.
Okay.
And so therefore you can get around the attorney costs of $5,000. Sometimes it goes even to $10,000 or more, probably.
That's beyond my means. The rule requires that prosecutions for simple misdemeanors be commenced by filing a subscribed and sworn to complaint with a magistrate or district court clerk or clerk's deputy. Following a hearing, Judge Novak found that the complaint was subscribed to and sworn to by the arresting deputy, and the complaint was subsequently signed by Judge Agley. Now, following a conviction by a jury, and by the way, I'd like to hear from the jurors in the case of John Harvey, or State versus John Harvey. You goofed. And there must be some reason why you were that far off. You should have known, you should have been able to smell a rat.
Well, I think that it all goes back to the CSI or law and order mentality.
Yes.
That's what I would call it.
Is that it?
That's
yeah.
it. You know?
Yeah. That's the law rules.
Statistically, if you look in the law books, there's statistics on what your chances are of winning if you're a defendant in a criminal trial. And I think it's somewhere of the order of about 10%, 5 or 10%, which is extremely low. So the assumption of innocence is it appears to be a faulty assumption of presumption of innocence, because that would, to me, implicate that people automatically assume that you're guilty. So that whole notion of you're presumed innocent is just only that. It's just a notion.
It's a fancy.
It's a fantasy, because you know, we live in a world or in a society that, you know, largely is considered naive by the rest of the world, especially in the past couple years. I've read a lot of different periodicals and seen a lot of different news reports from around the world, you know, because we've got satellite TV and stuff like that. Now you can get all these channels from all over. But I think part of the problem is we've been just inundated with CSI and Law and Order and Hill Street Blues before that, and you know we've come familiar with all these characters in these law shows and cop shows, that the average American just seems to believe that, hey, you know, if the police says that somebody did something wrong, they must be right. So
Then there's the premier of all concepts, and it's called Bad Boys, Bad Boys.
yeah,
What you gonna
exactly.
do?
And we never get to see those rare cases, whether it's in the media or whether it's on actual shows where they goofed. I was kind of shocked that they had a recent episode on CSI this past year where they reportedly messed up. You know, one of the guys in the CSI show messed up. That is a rarity. So, but you know, those of us that study stuff like this and read about stuff like this know that it happens a lot more than what they put on.
I've been going through some papers, tossing some and keeping some, but one of them was an artist that was shot in the back by a fellow by the name of Officer Gillespie in Iowa City, and the officer was doing his job. He was checking doors, and he couldn't figure out why a door to an office should be open at 1:30 in the morning. Well, it was an August day, and without the air conditioning on, it was a good idea to have the door open for to let some air in. Well, he came in the officer came into the room where the artist was working. In fact, he was talking on the telephone, and the officer was threatened, felt apparently threatened, and so he shot a guy in the back, you know, and the fellow by name, I think it's, or the prosecutor's name was White. I forget what the name of the artist was, but
Threatened is a favorite term.
Yeah.
Your deputy was threatened, wasn't he?
That's right. He was threatened by a 69-year-old senior citizen, you know, carrying equipment.
It
Can
was
you imagine?
About not only 15 years older, but about 6 or 7 inches shorter on top of that.
That's right.
I just really find that hard to believe. And you know, you've never had problems with the law at all. So I mean, I just find this ridiculous that you know they would be down there bothering you.
That's right.
Especially that you have camera equipment loading you down. Well, you're very threatening if you're leaving the courthouse building and you got camera equipment in your hand, John. That's grounds for us to stop you and grab your arm.
Right.
You know, it just goes beyond me.
We'll have to go back
stuff.
and comb through some of those
Yeah,
tapes
definitely.
to show that pro se people can make mistakes too. And I wasn't up on my objections. There's about 9 different kinds of objections that you can enter, and I wasn't entering the objections as fast as I should have entered them. Well, back to the ruling, which I think is a classic ruling, because before John Harvey's case came up, they weren't even doing and they had no intention of going through this process of swearing out their warrants. So now, following a conviction by a jury and an appeal, the state moves to dismiss, conceding for the first time on the record by professional statement that the arresting deputy did not sign and swear out the complaint before a judge or clerk. That being the case, the motion must be granted in conformity with Cedar Rapids, City of Cedar Rapids versus Atkinson, 617 Northwest 2nd, 272. That was an Iowa 2000 case. It appears from Judge Novak's pretrial ruling that no testimony was taken regarding the circumstances. You know why? Because he said, well, I can't overrule a prior judge's decision. Well, sorry about that, Judge. You better go back to school, because you can overrule on jurisdictional questions. I'm just a pro se person, you see, but I won because I cited the law all the way through here. And finally, there was a judge who was noble enough to follow the law. That was Judge Robert Blank. It appears from Judge
And
Novak's
you got publicity too.
publicity helps a little.
Yeah, that helps a lot.
Pretrial ruling that no testimony was taken regarding the circumstances of the arresting deputy, and the district associate judge signed the complaint. From a review of the preliminary complaint, it appears that the complaining officer signed it on March the 25th, and Judge Agley signed it on March 28th. The written record does not support a conclusion that a complaining deputy made an appearance before the public official empowered to administer an oath as required by Astinger. Indeed, the state now concedes that did not take place. Well, if it didn't take place in December or February or January or February, how is it they went clear through a trial and they knew what they were doing? Jeffrey Allen or Justin Allen knew precisely what he was doing. In fact, he even stated that they didn't do things that way, and that he also stated that they were if the court held them to that, they'd be in real trouble. So those of you that have warrants like this out, you might want to file a motion to set aside judgment. I don't know how that'll work, because I'm a pro se person. I try to protect my own legal interests. I'm not going to attempt to work on yours. Did you have a
Yeah, I had a little bit to interject there on that issue. I found it extremely shocking how Judge Novak, the trial judge in your case, just ruled. I mean, in writing. I wish you had that ruling there to put on the air. He put in his order that the deputy had sworn an oath on the complaint. Okay, he put this in his ruling. Okay, there's no way that he could find that. When you look at this complaint, there is no notary stamp, there is no seal, and this is why the court case got overturned.
But that's a file stamp there.
Yeah, and the judge just said, "Oh, there's a deputy swore an oath to that complaint." Well, I'm sorry, but where the heck do you see a stamp? Do you see a notary seal on there? It's there. I see something down there that says file, but that's not a notary seal.
That's a clerk's.
Exactly. There's nothing that says subscribed and sworn on this, and that brings me to
Would this be the only one in history that came after John Harvey without putting a notary on it?
I guess from what Justin Allen was saying, they've been doing that a lot. So if you
They admitted that right on
Yeah.
record, didn't they?
if people have got a complaint from the Polk County Sheriff's Office and it's not a notary seal or something on there, well, guess what? You might want to have them throw it out. That's called devoid of jurisdiction. There is no jurisdiction if they don't have what's required under Article 1, Section 11 of the Constitution,
That's
which
right.
is affidavit sworn under oath. There's also an interesting article along this same line of thought here from Professor Anthony D'Amato from Northwestern University. He wrote an article entitled "The Ultimate Injustice When a Court Misstates the Facts." I find that this goes on a lot. This happened in a couple of my cases that I've appealed. Matter of fact, there is one court case right now in front of the Iowa Court of Appeals. It's under 03-1173, Terrance Walker versus State of Iowa, in which the court did exactly this. What this professor is stating, and this is one of the few gutsy professors who actually has taken on to take on these kind of issues, which questions some of these judges and some of the things they do. But what he was saying in his article, he said he was examining another case, and he said Judge Easterbrook's deconstruction of the facts of the Branyan case displays great stylistic skill in persuading the reader of Dr. Branyan's guilt, but it also displays a curiously casual attitude, an attitude that even demonstrably false things can be stated as factually accurate in a judicial opinion because the reader typically would not question the accuracy of what a judge reports as the facts. Okay? This casual attitude is itself perhaps a byproduct of legal education. When a student is asked to make a legal argument on behalf of a party who, according to the given facts, should clearly lose, professors will not accept a student who says that the party should simply lose. Instead, they encourage students to come up with any arguments, however contrived, on behalf of the party who should lose. We encourage glibness. We penalize honesty. We applaud fabrication. We discourage sensitivity of justice. We tell our students that it is not the attorney's job to make a judgment about right or wrong, and rather to represent the client irrespective of right or wrong. That training, which we take pleasure in imparting in our classes, has its effect upon those one or two students sitting in the classroom who will someday become judges. They too become cynical by our persuasively amoral, technocratic approach to legal solutions. Do judges routinely display a casual attitude toward the facts of the case? I suggest that practicing attorneys be asked whether they have had cases where the judge's statement of the facts were false. And in my case, yes. If you look up the case Terrance Walker in the Iowa Court of Appeals 03-1173, you will see fabrication. Every practicing attorney to whom I've asked this question has responded in the affirmative. Some have told me that the practice is unfortunately quite common and that judicial misrepresentation of the facts of cases has produced a crisis in their professional lives. They feel that their work is subject to the whim of judges who play God with the facts of a case, changing them to make the case come out the way the judge desires. Some say that if they had known that the practice of law would be like this, they would not have gone into this profession. Professor Monroe Friedman recently stated in a speech to the Federal Circuit Judicial Conference, "Frankly, I have had more than enough of judicial opinions that bear no relationship whatsoever to the cases that have been filed and argued before judges. I am talking about judicial opinions that falsify the facts of the cases that have been argued, judicial opinions that make disingenuous use of or omission of material authorities, judicial opinions that cover up these things with no publication and no citation rules." And Professor Friedman wrote a letter to this Professor D'Amato in which he stated, after the speech, he stated, "You don't know the half of it." So, this is what's going on here in our court system in America, especially here in Iowa. There was a case involving myself in Story County in front of Judge Heckman. He's a judge who I've appealed a case on. Well, I don't have time to go into all the details, rather short show, but I will say this. He's just recently retired, thank goodness. Judge Sheckman retired out of 2nd District Court. He was in 2nd District, will cover Story County. But he took liberty with the facts, and that's just another nice way of saying that he lied in the actual order, so to deny me the fact. Just like your judge in your case said, "Well, the deputy swore an oath, so we're going to overrule your objection, Mr. Harvey." Well, the thing is, what happens to these judges? Nothing. They're not penalized. They go on doing their dirt. And the media largely does not pay any attention to it whatsoever. Thank God for this show. That's all I have to say on that. But Judge Sheckman, he retired February, I think 3rd of this year. I just wanted to say congratulations on your retirement, and he was definitely, or you were definitely the type of judge that couldn't judge a bubblegum contest. So that's all I have to say on that subject.
Okay.
I'll pass it back to you, John.
Yeah, okay. I've got a couple more paragraphs to read in this ruling, and then we're going to go right back to listen to more details about some of these other cases that are happening around the nation and unfortunately happening in Iowa. It's a real crying shame when you see courts that are asking for $127 million to run the system, and then asking for more and more money because that isn't sufficient funds to run the system. And then they're actually ruining the system of justice for Iowa
They're,
citizens.
they're
And
creating a system whereby it's more and more costly because of their aberrant rulings in which they seek to continue these malicious prosecutions, just simply because you are not a represented party.
that's
So,
right.
the prosecution can sit there and say, well, let's just continue the case, judge, and the judge will go right along with the case and just let you go through the procedures and rule all the things that you say against you, no matter what, and change the facts, no matter what, just so he has a hidden agenda. And I think that what that they Judge Novak said something. He was grandstanding in the proceeding. I wish you had a copy of that. He went on to say how noble the court systems in the United States are, and we've got the best judicial system in the world. Hogwash. It's just not being reported upon. And like I said, thank goodness for this show. I've got another article here right quick. I don't want to take
Go
up
right
too much of your
ahead.
time, but this is from February 7th. It's reported. Uh, the the title of the article, or the headline, is reported by Aurelia Calica. 56 hoodlums and rolls penalized by Supreme Court. 56 erring judges, or so-called hoodlums and robes, were penalized by the Supreme Court last year, with some being dismissed from service. Speaking at a conference on judicial excellence, Justice Arminio Paganabam said 582 judges have been disciplined by the High Tribunal for unethical conduct since 1986. They are the scum and scourge of the judiciary, he said. Legally knowledgeable judges who have no regard for ethics are dangerous to society. They may turn out to be worse than the criminals they sentence to jail. Quoting figures from the Office of the Court Administrator, Panginaban said most of the 56 judges were penalized for bias, dishonesty, misconduct, immorality, abuse of discretion, undue delay in rendering decisions, knowingly rendering unjust judgments, dereliction of duty, negligence, and conduct unbecoming. Panginaban, chairman of the Supreme Court's 2004 Judicial Excellence Committee, urged erring judges to transform old habits of laziness, ineptness, and duplicity into ethical values of industry competence and honesty. Now, this guy who went through and actually did something about this in Manila, this is the Philippines. I think that we need to stop saying that we have a great system of justice and say, hey, we need to be looking at the Philippines, because that guy over there, he took some action. We don't have any action hardly be taken. We've got a Judge Weaver, out of, I believe, what county was it? Was 2 months ago. He arrested 2 or 3 times for drunkenness while driving, and here he's getting a retirement of almost $90,000 a year. So this is the kind of justice system that we have here in Iowa, and they twist the facts, and they want to convict someone for bringing a camera to court when they're rightfully in court with the camera by court order. It just doesn't make any dang on sense. So I think we need to look at the new beacon of justice, and the new beacon of the judiciary in the world is the Philippines, because they take action and they get rid of their crooked judges. We keep them on the bench, or either we give them retirement pay.
You mentioned the problem with Judge Novak's ruling, the fact that he said that there was indeed that the deputy did indeed swear to this. As I read through that ruling, it was quite obvious to me that that ruling was written by the prosecuting attorney, and I think that if we looked into things, we might be able to discover that the prosecuting attorney was responsible for writing that ruling. Judge Novak, of course, had the responsibility of signing it, but he probably should have read it first. These judges have a habit of these judges have a habit of sticking up for one another. So I want to finish out this ruling, and then we're going right back to hear other dramas in the courtroom. Some of the things that have gone awry and make it difficult for people who work in our area, in vocal and others, to make headway in court, particularly since we can't represent individuals in court. We can only assist them in making their own representations. Well, here it is that it appears from Judge Novak's pretrial ruling that there was no testimony taken regarding the circumstances, and the written record does not support a conclusion that the complaining deputy made an appearance before a public official empowered to administer an oath as required in Assinger. Indeed, the state now concedes that it did not take place. Accordingly, the conviction is reversed. Well, thank you. I don't need a criminal conviction. And the case is dismissed with costs assessed to the state, including the costs associated with the preparation of the trial transcript for the purpose of appeal pursuant to Iowa Code Section 625.9. So ordered on this, the 7th day of February, 2005, signed Robert J. Blank. And apparently he must have taken into consideration the record that he was asked to look at. And here's his signature: Robert J. Blank, who overturned this decision of the jury. And of course, like Terrance says, that once you get into this grinder, and you can't talk about anything except what happened on the 24th, but they can lie through their teeth, and I have to give the title of liar to the deputy Grayling Ashley. Not only is he a liar, but he is actually a cheat, because he is taking in excess of $55,000 in salary from Polk County taxpayers for engaging in a practice which was totally illegal, totally false, lied through his teeth in bringing about this action, which cost taxpayers several $100s. Now, it cost me initially, but I'll get that money back, because the county is obligated to back him up and to pay his debts, the debts that he incurred. And I think this is a crying shame. Let's move for the next few minutes to other stories from our courtroom consultant, Terrance Walker.
Okay. We had a couple other interesting things from around the country on the judiciary. I wanted to first point out that we did have a couple things from right here in the Midwest here. There's KCAU TV Channel 9 reported last week that judges are under fire. Some Siouxlanders are unhappy with their court system, and now they're taking the law into their own hands. This is from Sioux City, Nebraska, on the other side of Sioux City. Orrin Abendroth and Gerald Kubik both think their cases were mishandled by Nebraska judges, and now they have a bigger goal than just winning their cases. Orrin and Gerald's legal battles started about 2 years ago. Orrin's a case against a local bank, and Gerald's was a divorce. What they have in common is their experiences with District Judge Robert Inns of Cumming County. All he knows is how to dismiss our cases, and the reason why is because Myrna Ricker, the clerk of the district court, won't even put our cases on the docket to be heard. Orrin says his case was passed on to Judge Maurice Redmond in Dakota County, a man recently criticized for problems with timeliness and performance as a judge. With numerous complaints over the handling of their cases, Orrin and Gerald felt they had nowhere to turn. I had filed complaints with the Judicial Qualifications Commission, which we also have here in Iowa, by the way, similar one, as well as the Council for Discipline against all these people. And this is an example of what's been filed. Everything, each and everything was dismissed. Now the men are trying to help themselves and each other. It is basically, all it is reading. Everything's in the statute. It's all there in black and white, Gerald said. They said their research leads them to believe the judges Enns and Redmond and District Court Clerk Myrna Recker should be impeached. On Tuesday, they filed papers saying so, an action usually only taken by a Supreme Court justice. This is something that has never taken place in the state of Nebraska. No attorneys would even approach anything like this, Gerald said. It's about time our court system gets cleaned up and they finally start doing something by the law. Orrin and Gerald say they know other people who have had problems with Judge Enns and the District Court of Clerk and have been sending back some of their paperwork unopened. Judge Enns says he has no comment on the accusations or the impeachment issue. Orrin Aberrath says he expects to send a notice of intent about the impeachment in 15 days, or he'll take further action. So, I mean, there we have it. People right here in the heartland, not too far from us, experiencing the same exact mendacity. It's out there. Believe me. We've even got case here in Iowa here, down in Davenport, where a lawyer who has complained, several of the judges, is basically being blackballed from receiving cases from the public defender's office. So, you know, they try to question her credibility in the paper, not only the Des Moines Register, but in the Quad City Times the past few weeks. But Sally Machetta, I believe is her name, she responded in the paper that she's won 10 out of 12 of the jury trials that she's been in. And I would have to say that that is an impeccable record for jury trials for a defendant, especially a criminal defendant. It's like I was saying earlier, the statistics on that, 5-10% tops you're going to be looking at as far as winning those kind of cases. So it just it just reflects to me that there must be some political firestorm over there by the judges to blackball this lawyer and prevent her from obtaining more work for her actions and complaining these judges. And I think it's high time that we start impeaching some of the judges here in Iowa as well.
That's the truth. Okay, we're going to go to that courtroom scene, State versus John Harvey. We're going to only hear a part of the presentation because you and Don, Terrance, read the transcript of the earlier part of this thing. So we're going to talk about the nitty-gritty here of the deputy's testimony. And you might hear the word liar at the appropriate times, because I think that we will leave the mics wide open here.
How do you spell that word, John?
L-I-A-R. Liar.
I thought you
that
was
means
going to say
misrepresentation of the truth.
I thought you was going to say ASHLEY.
Yeah. So it's either the equipment making a faulty noise here, or we may actually be voicing an opinion regarding this person who is speaking. So just in case you need that extra information, we'll provide it for you. Here now, the courtroom scene of
cameras for those occasions.
State versus John
Also,
Harvey.
it's the employees when they have a
And who is this,
party
John?
or a shower.
This
on
is
occasion.
Grayling
They're at the
Ashley.
courthouse,
The deputy in
to film
question.
these activities.
That's correct.
Is the sheriff's department charged with monitoring that activity and supervising video equipment that come in and out of the courtroom?
We don't necessarily supervise the individual themselves. Basically, what we're told, once we have a verbal okay from the judge, those individuals officers are allowed to bring those cameras into the courtroom, but before they proceed to take any photographs or video, they have to have permission from the judge himself or herself.
Okay, and on March 24th of this year, back to the conversation you were having with the defendant, did the defendant give you any indication that he had a judge's permission to bring the video equipment into the courthouse?
He tried to pass off the order that stated that Mr. Bechtold had an appointment in room 202 as his mass media coverage authorization.
What did you do after seeing that?
I told Mr. Harvey that wasn't in order. I would go upstairs. He was to sit outside of room 102, and I'd go upstairs and talk to the judge to see if he allowed the camera into the courtroom.
And did you ever confirm that Mr. Harvey was allowed to have a camera in the courtroom?
Yes, I did. I went upstairs and I spoke with Judge Price.
Do you recall how long that took to get that confirmation?
35 minutes.
And after that, did you return back to the first floor with Mr. Harvey?
Yes, sir.
And what happened then?
I instructed Mr. Harvey that I was going to escort him up to room 202A, and Judge Price requested that I stay with him until his
Liar.
was done.
And did you stay in the courtroom?
Yes, sir.
What did Mr. Harvey do? What did you observe him doing?
Mr. Harvey spoke with Judge Price, tried to find out if Mr. Bechtold was indeed scheduled for that day. He wasn't. Judge Price basically told Mr. Harvey that he could bring his camera into the courtroom. The only people that he was to photograph or videotape was the judge himself, the court reporter, and the person standing in front of the judge.
I'm sorry, just so I'm clear, did you say that Mr. Bechtold, the person that Mr. Harvey was there to videotape, did not have a court date that day?
No, he was scheduled for the following morning.
Did Mr. Harvey ever set up his video equipment in 202?
No, sir.
Yes, he did.
Eventually, did Mr. Harvey leave 202A and proceed downstairs to exit the courthouse?
Yes, sir, he did.
Were you with him when he did that?
Yes, sir, I was.
Why?
Judge Price asked me to escort him out.
Did anything unusual happen while you were on the second floor with the defendant?
Nothing necessarily out of the ordinary, other than I tried to explain to Mr. Harvey that the following morning he was going to go through the same scrutiny coming into the courthouse, and he was expected to bring his cameras back.
What happened on the first floor between you and the defendant?
Mr. Harvey was pretty well agitated.
Liar.
He initially escorted him upstairs, blaming the deputies for holding him up from a court date and a court time. We tried to explain to him
How many witnesses did he have to that effect, John?
with his camera. It was an order signed by
None.
the chief judge. And I tried to explain that going down the stairs when he was finished in 202A. At which
Maybe
time
that's why he
raised
didn't
his
swear
voice and
nothing.
told him to calm down.
Liar.
He kept yelling, "I want to see this order, I want to see this order."
Liar.
At this time, we were outside of room 103, and I grabbed a hold of his left elbow. And
Liar.
he pulled away from me.
Liar.
A closed fist. At that
Liar.
time, he did his movement to the wall.
What prompted you to grab his elbow?
Him getting belligerent,
Liar.
raising his voice, very agitated. I just told him he needed to leave the
Liar.
courthouse.
Did his behavior or potential behavior and his raised voice and, as you described it, belligerent actions, did that concern you in any way?
To the point that it was going to disrupt anything that was going on in the other traffic court. And when he turned towards me with a closed fist to my seat.
Your Honor, I wish to enter a belated objection. The objection speaks to what Judge Price's part was in this. That is mentioned nowhere in any of the court record at this point. I think it would be inappropriate. not to enter an objection to conversation which I have no way of defending myself from when it is not in the original charge.
Well, the time you're making an objection when the testimony was elicited, so that your objection is untimely at this time. Proceed.
Was Mr. Harvey, the defendant, carrying anything in his hands that you can recall?
I recall him having a black camera bag, and I believe it was either a yellow or an orange drop port.
Was that one in each hand or both in the same
I
hand?
had both in his left hand.
Liar.
And just because I can't remember what elbow of Mr. Harvey did you
Right, his left elbow.
Liar.
grabbed the same arm that had the
The bag.
equipment?
Yes.
Did the reaction that you've described about Mr. Harvey turning towards you, did that happen immediately after you grabbed his elbow?
Yes.
You recall him saying anything at this point?
I don't recall exactly what he was saying, other than, I want to see the order. He kept screaming, I want to see the order.
Liar.
Do Mr. Harvey's actions interfere with...
Object to the previous testimony here, Your Honor. There's nowhere in any of the complaints where the deputy said anything about wanting to see the order.
Overruled. I'll rephrase the question, Deputy. Did the defendant's actions in any way interfere with what you were the duty you were trying to perform this morning? Not this morning, but the morning we've been talking about.
Yes, it was to keep the peace within the courthouse.
And you said you redirected...
Object. Nothing objective about keeping the peace. Nor was that in the original complaint.
Overruled. Proceed. You said that you redirected Mr. Harvey to the wall. Why did you do that?
For his safety and mine,
Liar.
turn the closed fist.
Did you feel that he turned in a threatening manner?
Yes, sir.
Liar.
Object to the question of leading.
I'll sustain it as to being leading. Jury will be admonished to disregard it based on a leading question.
Why were you concerned when Mr. Harvey turned to you in the way that you described?
It was a quick, jerking movement. When he turned, his fist was coming towards my face.
Liar.
What exactly did you do next?
I redirected his movement to the wall on 103. At that time, I proceeded to handcuff him.
Did you place him under arrest?
Yes, sir, I did.
He wasn't concerned
What,
about
sir?
the cameras flying
Very
around at
fierce
the same
resistance.
time as your fist?
Nope.
He always talks about your fist and never...
This
I don't know,
probably
couldn't
goes
help
without
but see
saying,
the
but the
cameras
events you
hanging out of
described
your
that
hands.
occurred in the Polk County
That's right.
Courthouse. Is that in Polk County, Iowa?
Yes, sir.
Just a couple more questions, Deputy. At any time during your interaction with the defendant, did he indicate to you that he was having difficulty hearing what you were saying?
No, sir. That was not divulged until we got across the street in the booking area when I was asking him his health questions.
At that point, he gave an indication about his hearing loss?
Yes, sir.
When you were explaining to him about the administrative order that you described previously in your testimony, did he ever give any indication that he couldn't hear what you were saying at that point?
No, sir.
Did he ever ask you to repeat what you had said?
No, sir.
I have no further questions, Deputy. Thank you very much.
You may cross-examine Mr. Harvey.
You testified, Deputy, that it was an affront to you because the defendant had closed hands. Is that correct?
What was your question?
What was your
Is it
question?
part of your accusation that the defendant had closed hands?
One hand, his right fist.
Did your jailhouse report that you had two closed hands?
Negative.
Pardon?
Negative.
Liar.
What
We'll
is
look at
this
that,
negative stuff?
when we call you. You say that the defendant quickly made a quick jerking movement towards you. Can you enlarge upon that?
You jerked your hand out of my grasp. You turned to pivot towards me. Your hand that had the bag and the drop cord stayed to your side, and your right hand came towards my face.
Should have
was
come
in the
toward
right
his
hand?
face.
Your fist.
So you're in
What was in
custody
the
at
right
that time
hand?
when he was gripping
Right.
you.
The right hand grasping.
Right.
It was in a fist.
Liar.
I won't approach the witness, I'll just approach him here. Does this roughly depict what I was carrying away from the courtroom in near room 103?
Those are the two objects that you had. It's not depicting the way that it was. Place the yellow thing in your left hand.
The yellow thing was in my left hand.
Put the camera back in the same hand, right there.
So you're saying I had one hand that was free,
Yes, sir.
and it was this hand that came close to your face.
Yes.
And you didn't mention that in the complaint, did you?
No, I said it turned with a closed fist.
It turned with a closed fist. But you testified just now, did you not? That fist that was free to move was up near your face,
Yes.
and you were afraid,
Liar.
but you in fear.
Yes.
How large are you? How tall?
5'9",
And what is your weight?
probably 190.
Should you be really afraid of somebody who is 5'4" and carrying this much gear?
Yes.
Poor boy.
So you're telling this court that you were fearful of an individual near room 103 who turned in a jerking manner and had his fist near your face.
Yes.
And your defense mechanism was to arrest?
Yes.
That's all, Your Honor. I'll reserve the right to recall.
Well, that gives you an idea of what kind of.
You're reserving the right to call.
just a
Correct,
second
as
there.
you're with.
We'll see if we can get that shut off. That gives you some kind of an idea of what I was facing when I was in court. You can take a deputy who can lie 17 times, per minute, and give a story, and no backup witnesses, no one that you can cross-examine on the facts of the case.
And a judge that couldn't judge a pie eating contest.
That's right. Well, we appreciate your dropping by the CPI report. We trust that you'll give us a call if your family has a need to and a brush with the Department of Human Services. And thank you, Terrance, for dropping in on us and with us and assisting. And thank you, Don, for
You're welcome.
your part in it. And we'll see you next week.